use that. Yes, welcome to the No State Project live from LRN.FM and streaming, of course, live on my YouTube channel, which is No State Project. Glad to be with everybody here today. We're live in California, so you have to excuse the quality of the video. It actually looks pretty good from my side, but I don't know. But I'm glad to be here with everyone. The number is 218-632-9399, 218-632-9399. Again, it is June 23rd, 2018. 3 hours of Anarchy Radio right here on the Liberty Radio Network and my YouTube channel, No State Project. So if you're not subbed, get subbed so that you know you'll get a message whenever we are streaming live. And yes, you can also get me on Skype. It's Frank Rizzo 3, Frank Rizzo with the number 3. Instant message me first, of course, as always. And we'll get you up on the big broadcast there, don't you know? My mic is overdriven. I will maybe, okay. Hopefully that's, it doesn't look that way on, well now, really. Hopefully we can get that squared away. It doesn't, well, all right. Well, it looks like we're doing pretty good here. So, hopefully that's taken care of. All right, so we'll get to everything. I want to thank everyone for the continued support of the big show. As always, if you want to help support the show, you can do so by going to markstevens.net, going to my sales page. So anyway, a lot of stuff to get to. Before we get to any calls, what we're going to do is, like I mentioned, I know this is raising some questions here. I thought we would talk about the Ten Commandments today. The Ten Commandments. And I didn't mention which Ten Commandments, though, but it's basically the Ten Commandments of rational argument, or the Ten Commandments of logic. Now, I didn't write this. Somebody just put this together a number of years ago. I think it's pretty cool, and I figured, hey, we're talking about anarchy and using that perspective when we go into court, being a skeptic and not accepting sacred cows and always challenging things. And what better thing to understand than when you're going when somebody's making an argument that we don't violate these Ten Commandments, that we don't take a burden of proof upon ourselves, we don't allow people to argue with faulty logic and then make excuses. You know, so when we're going into court, if that's what you're doing, or you're going into a city council meeting, and which I really hope we get some people to start doing that. I actually need to be able to start doing that again myself. When you're asking the questions for people to support their arguments, if you know your Ten Commandments of logic, it's a pretty good bet that if you understand at least this little bit, that you can hold them to their burden and expose them for the charlatans that they are. Of course, it's easy when you're asking leading questions, because leading questions require a yes or no answer, so you know if you're getting a responsive answer or not. Again, if you don't understand what a leading question is a question that has the information you're trying to elicit in the question, as opposed to a non-leading question, which does not give the information. The person who's being questioned has to supply the information, and you're not leading them to a certain conclusion. But leading questions are extremely effective, and always lean on the leading question. Chances are, if you're asking leading questions, you're going in the right direction, and you should be a lot more effective in your questioning and holding somebody's feet to the fire to support their claim. So here's a big one that, of course, I encounter all the time. Not as much as some anarchists, but number one, thou shalt not attack the person's character, but the argument, which is why I typically, for several reasons, won't mention somebody's name on the show or their pseudonym. I will just attack the argument so that I'm not accused of stupid things like that. I have laid insults at people, and I do based on evidence that's fairly solid and irrefutable. Will refer to those called government as criminals, but that's because I'm not saying that their argument is necessarily false because they are criminals. There's no evidence their laws apply because they are criminals. But it's not really an insult. It's just saying what they are. It's describing what they are. When I want to say scumbag, yeah, that's an insult. And I'm not saying lawyers and their arguments are wrong because they're scumbags. What I'm saying is because of the way they treat people, how arrogant they tend to be, and how one in particular, I use this, never shut up and kept on interrupting. Yeah, scumbag or a douchebag move. But that's not being used to attack the argument. It's being used to attack their carrier. I can defeat and debunk an argument. I don't have to resort to that. So don't let them do that. And what comes in with number one here is attacking the person's character, not the argument, is gaslighting. And the extreme version of gaslighting, of course, is going to be if you're in court and they threaten you with a psychological evaluation. That is ramping up the stress on a psychological attack on you. Like there's not much more you can do without actually physically torturing somebody. So that I think comes in that. The gaslighting definitely goes in that to make you feel like you're crazy for even questioning something. Oh my gosh, we're just supposed to take it on faith that the laws apply because the laws apply as a matter of law. How dare you challenge that? So that goes right in it. So remember, attack the argument, not the man or the character. 2, thou shalt not misrepresent or exaggerate a person's argument in order to make it easier to attack. It's called the straw man fallacy. That's why what I like to do to avoid being accused of that is to confirm. Have them confirm what their position actually is. So a lot of times just in my voice, repeating the claim is usually enough to start casting some doubt on the person who's making the claim. Like, well, it sounded good when I said it, but when Mark says it, it really sounds stupid. Is that because Mark's an idiot and everything he says sounds stupid, but he's just repeating my... Doesn't mean that they're always going to back off, but in a lot of cases, yeah, just confirming it. So I mean, just like this week, again, I keep getting these common law type things. Oh yeah, I'm looking at the. Yes, this is a Father's Day gift, so I love the shirt, love avocados, love the guacamole there. So anyway, to get back, someone recently, because of all this stupid common law stuff, and was mentioning that something about the name in all caps. And you just read it back. Let me see if I can understand your position correctly. You're saying that some unknown bureaucrats in the government, when you were born, decided to trick your parents. And what they did was they convinced them to start using your name in the all caps, to accept the birth certificate, to accept the name in all caps. Because what they did was create a corporation. And for some reason that's undisclosed to us, with the creation of that corporation, there was millions of dollars created, in credit on that account. See, just saying that and getting them to confirm that's the position, like, well, but that's the position. It's the same thing where they say that you can literally be kidnapped. And you could be literally kidnapped and brought into court. That is any way that you're brought into court, literally kidnapped, that gives them jurisdiction. That proves that the Constitution applies to you. Just literally kidnapping you. Really? So never deliberately, especially deliberately, but always have them confirm what their position is, so that when you start asking questions, you're attacking the actual argument and not something that they haven't raised. We'll continue with the 10 Commandments of Logic here on the No State Project in just a few moments. For those who are tuned in on the YouTube stream, please keep in mind we're doing a live radio broadcast and we have commercials, so that's why we go silent. Listening to the No State Project here live on the Liberty Radio Network, LRN.FM. And also streaming live on my YouTube channel. I think there is kind of an issue with the audio on the YouTube stream, but I hope it's listenable. But I do know that the LRN stream is sounding great, and the audio that I will get posted with recording here on my side as usual. The MP3 will be up at markstevens.net. So hopefully it is fine, because you see this does not make for the best, audio quality. So, this damn wall, what are you going to do? What are you going to do? I'm glad I can, but anyway, let's get back to the task at hand that we got going over here. We're talking about the 10 Commandments of logic. And when you hear something stupid such as, you can't use basic principles of logic when you get into court or when you're talking about law in general. No, that's just absolutely not true, because the burden of proof is on the prosecution, which is a basic principle of law, a basic principle of logic. So, and if you look at most of your objections, you may be using slightly different terminology, but you're still objecting to the same thing in principle, such as objection, lack of foundation, relevance. These are basic principles of logic. Deductive logic is what a jury is using to make a decision on what's right, what's wrong, based on the evidence and the credibility of the witnesses that are presenting it. So the last one, we talked about, thou shalt not attack the person's character, which is an ad hominem. Thou shalt not misrepresent or exaggerate a person's argument in order to make it easier to attack. One of the things that they like to do to us, the Franchise Tax Board or the Board of Equalization, tax agents are absolutely notorious for doing this. We'll ask for evidence to support their claim, and they'll say, well, Mark, your argument that you're not a taxpayer within meaning of statute is frivolous. Well, that's not what we're doing. I didn't even say that. It's not the actual, that's why they just make it up. That's not even just misrepresenting or exaggerating your argument. They're just making it up so that they can defeat it. Another thing is when they turn around and say that your argument is frivolous and you haven't even raised an argument yet. Thou shalt not use small numbers to represent the all, which is a hasty generalization. This is very, very common, of course. People will like to look at one thing that happened, which we call it anecdotal, and say that it applies to the whole, and that is just not true. I've caught myself on this one. Not all lawyers are dishonest. They're part of a dishonest system, but they're not necessarily dishonest like Stephen Myrie is. They don't all rise to that level. Do all prosecutors engage in deliberate misconduct? No, but I'm going to take Kaczynski's and other judges' assessment that it's at epidemic levels. Doesn't mean they all are, but the evidence seems pretty good, and there's so many cases about it that epidemic. Thou shalt not argue this is number 4, thou shalt not argue thy position by assuming one of its premises is true. Oh my gosh. Is this like the be-all, end-all of, you could see why people in the legal system and rely on the legal system would say, well, you can't bring basic principles of logic into court. Please. Wow. Not argue thy position by assuming one of its premises is true. Well, what's one of the biggest offenses of this particular 10 Commandment of logic? Oh, that's right. Assuming that the laws apply. Let's not discuss that. Let's just discuss as if the premise has already been proven to be true. Well, Mark, the laws apply as a matter of law. Yes, but you're assuming your premise is already true. You're assuming that they apply. It's like this particular point, I don't think it's necessarily lost. I think they just don't give a damn, and that's where the douchebaggery comes in. That's where the real scumbag part comes in, where you completely ignore how irrational your position is. You just ignore the fact that you're assuming your premise is true. The idea that you can literally kidnap somebody in order to get jurisdiction. Where was the jurisdiction to kidnap them? Where does it? It's just, You're presuming you have the authority under the Constitution to kidnap someone so that you can put them into a court system, physically in court, so that there can be jurisdiction. Yeah, this is one very, very common. Yes, of course, it's begging a question. It usually goes right into circular logic also. So keep that in mind. Thou shalt not argue thy position by assuming one of its premises is true. You're going to get this constantly in court. I don't have to prove that. This is why I talk so much about actually conversing with the prosecutor and talking with these people outside of court. Look, we're not in court right now. Can you prove your position here and now? Because ethically, if you can't prove your position out of court, you damn well shouldn't be bringing it into court. Now, I'm sure that there'll still be critics that say, well, Mark is just making that up. Well, I'm not making up Rule 3.1 of the ethical rules. I'm not making up Rule 11 of the Civil Rules of Procedure, or at least the federal ones that were adopted, and the states that adopted it. It has to be based on law and fact. And if it's not, if you can't prove it outside of court, you have no business bringing it into court. I mean, one of the examples of that was this disgusting thing that the Attorney General did in Louisiana recently, that after a 2-year investigation and the crime is on film, decided there still wasn't enough evidence to even indict. So if there's not enough evidence to prove your case, you shouldn't be bringing it. You should definitely not be. So that's just a basic ethical violation. And if someone's going to say that I'm just making it up, well, I didn't make up Rule 3.1. And again, I didn't make up Rule 11. And I didn't make up basic principles of morality and ethics, that you don't bring a claim. And that's the thing. If someone says that that's BS, I'm making it up, ask them point blank. So you're telling me that it is ethical to bring a claim against somebody you know you can't prove? That's ethical? That's honest? That's moral? That's due process? Come on, give me a break. Number 5. We could actually spend a whole segment on each one of these particular ones. I mean, just not argue thy position by assuming one of its premises is true. You're going to find that this is extremely common, that this is one of the most violated rules of logic. And here the thing is, too, I got to mention, since, I'm still talking about this, I can guarantee you almost 100%, if you or I started doing the same thing and we argued a position in court as if one of the premises has already been proven to be true, there would be objections and we would not be permitted to do that. Not going to happen. Remember, turnabout. If the prosecutor is allowed to do something, you do it. And see how fast that they correct you, and see how fast the rules mean something to them then. All right. We'll be back here on the No State Project. We'll take your calls at 218-632-9399. 218-632-9399. Passcode is 2020. We'll be back with your calls and the rest of the 10 Commandments in just a moment. Yes, welcome back to the No State Project, live from the fortified compound in San Bernardino, California. And the LRN stream is doing well. So I do appreciate people tuning in on the YouTube, especially, you'd think I'd have more numbers when I wear such an awesome shirt. So if you're on just the LRN stream and you can't see go to my YouTube channel and check it out. So I'm glad to be back with you here. The number is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. You can also reach me at Skype at Frank Rizzo 3, and we'll get you on the big broadcast. So if you have any questions about court, about anarchy, getting to a voluntary society, then give us a call. And we're talking about the 10 Commandments of Logic, something that is sorely lacking and will certainly help you be a hell of a lot more effective in court if you know these. And so we have number 4, which was, thou shalt not argue thy position by assuming one of its premises is true. So, again, they are always assuming that the laws apply. And that is Yeah, that's bad. Remember, in law, when you're in court anyway, not just in law, but when you're in court, relevance is king. Your evidence, your logic, your legal arguments, none of it has any importance whatsoever. None of it can help you unless you can show relevance. Now, relevance is a very low threshold, but if you can't show the relevance and you can't even make that low threshold, it doesn't matter how much evidence you have, or it doesn't matter what facts and witnesses and whatnot. If you cannot show relevance, it doesn't matter. Relevance is key. So keep that in mind. And when we're talking about jurisdiction, it's a threshold issue. If they cannot show jurisdiction, if they can't show territorial subject matter jurisdiction and personal jurisdiction, they are tied together. They're both based on the same claim that if you're physically in California or wherever, that the rules apply to you. It's an element of the charge, for heaven's sakes, because they're charging you with a mala prohibita. They're charging you with a code violation where it's only an offense because the politician said so. So there is no crime without the statute. It's not the same thing as mala in se or something like a real crime like murder. Murder is criminal and immoral regardless if a politician said so or not. This is completely different. Mala prohibitum, it's only a crime or an offense because of that particular statute, that the say-so of the politicians. So they want to just assume that. So don't let them get away with it. Make your objections. Thou shalt not claim that because something occurred before, it must be the cause, post hoc, or it's the false cause. I get accused of doing this all the time, that we have a motion that is literally granted, signed by the judge, granting the motion to dismiss, and they're saying that I am arguing a false cause, that the motion to dismiss had nothing to do with the dismissal, such as in Chandler, Arizona, when we had a jury acquittal of one of the two charges, had nothing to do with the defense, had absolutely nothing. I am making it's a false no, it's not. And the assumption is that granting the motion to dismiss was just to get back at the prosecutor, because judges are in the habit of having prosecutors respond to motions that are legalistic gibberish and have no merit whatsoever. So instead of sua sponte, denying the motion because it's ridiculous, it is legalistic gibberish, makes no sense whatsoever, has no merit. No, they go ahead and they order the prosecutor to respond. Yeah, because that happens. Thou shalt not reduce the argument down to two possibilities. This is a false dichotomy. An example that we see in court is, sir, you're here for your arraignment. How would you like to plead? You can plead not guilty, or you can plead guilty. That is a false dichotomy. That's a false choice, because we know that there is door number 3. And door number 3 is to file a motion to dismiss or to object and challenge the sufficiency of the complaint and their assertion that there's jurisdiction. Okay. I know I have been accused of a false choice where the judge will, for example, the judge will insist that there's jurisdiction, and I object and ask a nice leading question: is that because you say so, or because the prosecution's evidence does? That is not a false dichotomy, because there is only two choices available there. The judge is either making his determination based on the evidence the prosecution has given him, or he's not. Which in that case, if he's not doing it based on the evidence that the prosecution's presented, then he's doing it because he said so. Maybe because the judge has determined independently. Let's say he's some dead lawyer. Some dead lawyer from 150 years ago said something in a court case, as if it has any relevance to the facts today, which they don't. So this is a very common thing where they will always leave out, the other options. So again, thou shalt not reduce the argument down to two possibilities. There's going to be some cases where that's true, but it's not very often. And you should be able to explain exactly why there's just the two. Number 7 is, thou shalt not argue that because of our ignorance a claim must be true or false. Well, this is getting into the whole thing like Bill O'Reilly. Tides go in, tides go out. Can't explain that. Must be God. Yeah, and I wouldn't. I would also say on this particular one that just because an IRS agent can't produce any evidence to support his claim that the Constitution and laws apply because I'm physically in Arizona, that in and of itself doesn't make the claim in general false. It doesn't mean somebody else can't prove that. It just means that this agent that we're relying on is not capable of supporting his decision, and it should be tossed out. It's not up to somebody else to prove that. It's just like the police officer who writes you a ticket. If he can't support his claim, it doesn't matter if the police chief thinks he can. The police chief isn't personally involved. He's not the one making the claim because the burden rests on the one who is making the damn claim. We got to always keep that in mind. Even when you are in court or a legal proceeding. Because they like to say that it's presumptively correct. See, this is where called cherry picking, which we should get to. Government agencies, or no one gets a presumptively correct argument or presumptively correct claim or presumption just because they make a claim. They have to have some facts that, if accepted as true, would support the claim. That creates a rebuttable presumption, or that creates a presumption of correctness. So Adamson versus Commissioner is one of the many cases. That's the United States Court of Appeals. I don't know the whole citation off the top of my head. It's easy to look up. That's one of the cases that lays out that the IRS, like everybody else, doesn't get a presumption of correctness unless it's based on evidence, because otherwise it's called a naked assessment or just pure speculation. You do not get a presumption of correctness on speculation. You do not get a presumption of correctness just because you make the claim. And again, if you doubt me on this, just look at the law of presumptions. Look at the case Adamson versus Commissioner to show support there. If you disagree, you call them on it. Object if they try to pull that kind of crap. And let them tell you. The prosecution is, look, the IRS is presumed correct where there's no evidence, or, they don't need evidence. Oh, so can I have a rebuttable presumption created if I just make an allegation with no evidence? Is that how it works in this court? We'll continue with the rest of the 10 Commandments of Logic here on the No State Project in just a few moments. You want to join me? It's 218-632-9399, 218-632-9399. The passcode is 2020 and the pound sign. Again, we will be going to commercial, so those on YouTube, we got about 3 minutes. Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network, LRN.FM, and streaming live, of course, on my YouTube channel, No State Project. And welcome back. We're taking call. Well, I will take calls, so you can get into the queue at 218-632-9399, 218-632-9399. And the passcode is 2020 with the pound sign, or 2020 with the hashtag. And you can Skype me at Frank Rizzo 3, but instant message me first. We'll get you up there. Oh my gosh. This next one, number 8. This one is huge, huge. It's bigly. They use this constantly. Wow. Thou shalt not lay the burden of proof onto him that is questioning the claim. Very, very common. Really good example of this when I confronted the Tempe City Council a few years ago. I had a great haircut at the time. Colby Granville on video without a hint of shame. We have jurisdiction because we said so. And it's up to you to prove that we don't. Again, you don't get a presumption of correctness unless it's based on fact. And that would then shift. And here, this is what they try to do. They try to say, well, the IRS will make a claim. Well, you prove us wrong. Do you have any evidence to support your claim? We don't need evidence. If you don't need evidence to support your claim, then how can you prove it's wrong? I mean, it's ridiculous. This is what they do. They have a prison system. And I can tell you, even if you did prove the IRS wrong, a lot of times they don't give a damn. They believe that they're right. No amount of I've had them admit that they had no evidence whatsoever. They don't care. Because you're not talking about people who give a damn about right and wrong. I mean, there was some recently, there was actually some journalism done for a very brief moment. Journalism that I respect anyway. And I think it was some government, a federal government official, and he was on CNN. And I can't remember the name of the guy who was asking. I think it was Wolf Blitzer. And they were talking about the policy of separating the children. And if that wasn't bad enough, a lot of them are lost and don't get back to their parents and are in the hands of traffickers. So the question that the host asked was, is this policy humane? And all the guy could do was respond with, I follow the law. And just, that's not the question. The question is it humane? And he wouldn't answer. So they don't give a damn. They follow the law. And they don't care whether it's right or wrong. They don't give a damn. So they'll try to push the burden on you. But really all they're doing is delaying what may be the inevitable, which they're just going to say, Abba Fangul, and they're going to come after you anyway. And so Michael Marconi is an excellent example of that. I mean, he's an IRS agent. I've mentioned him on the show before. He admittedly had no evidence. And when I confronted, well, wouldn't due process and fairness dictate that you not proceed with a levy and destroy someone's life until you do have such evidence? No, I think the best course of action is to do a levy anyway. Oh, instead of just waiting for evidence? Because they don't care. So with a lot of bureaucrats, it's not even just that they are, they're just trying to, out of ignorance or fear of looking stupid, to push the burden on us. No, they're just doing it to delay the inevitable. That they're going to do whatever the hell they want anyway most of the time. But this is a very, very common tactic. Well, prove to me that the laws don't apply. Prove to me the laws don't apply. I can do that. That's really easy to do. But you got to remember, when you're engaging people, keep them to their burden of proof. Keep it on them where it belongs. Don't allow them to shift that burden. No, you prove it doesn't apply. No, you are the one who's claiming it does. You bear the burden. You have to. So another way they'll try to do this is they'll say, Mark, what evidence are you looking for? And it sounds like it sounds like they're saying to you in good faith, Mark, I want to work with you. I want to help you. I just want you to tell me what you're looking for. Do you believe that X equals Y? Yes. Why do you believe that that's true? You've already made up your mind. You believe that X equals Y. Why in the world would you need input from me? Again, most of the time I think it's a douche move. It's just somebody is caught with an argument they cannot support. Well, what kind of evidence do you want? Just tell me what you're basing your claim on and we'll take it from there. See, another variation of this comes down to no amount of this is a real scumbag move. No amount of evidence I give you will convince you. You know what? Stop trying to predict the future, jackass, okay? And just lay the evidence on the table. You know, if you've got people listening or watching something like that, smart people, rational people who understand the 10 Commandments of logic will realize you're just being a scumbag. You're being a douche. You cannot support your claim. It's no different than these politicians. Is the policy humane? Yes or no? I follow the law. You're not answering a question. But by not answering a question, you're basically admitting to everyone, or convincing everybody, most people anyway, that you just can't support your argument. You know that it's inhumane. You know that if I was to do business like governments and that I was to force strangers to give me money, you know that's criminal. You know it's immoral to its core. And That's why you don't answer the question. So I don't need you to answer the question necessarily. So here, if we're going in court over with the IRS, we use that against them to show that there's bad faith, that they're not being fair with you. Well, they're not there to answer your questions, Mark. Yeah, you are there to support your claim. If you're going to due process demands and fairness and traditional notions of fair play and substantial justice demand that if you're making a claim against somebody that affects them, you have to support it. Speculation does not count. Because if speculation counts, it should count for everyone. And believe me, you don't want a bunch of anarchists like me going into court and speculating against you when you're trying to put me in jail. It's not going to, it's going to get ugly really fast, as it should. Because speculation should not be permitted. That's why we never take, this is why I told someone just, several times this week. Our premise when we go into court or when we're trying to resolve these conflicts, the spotlight is always 100% on the accuser. They're the ones that we are putting on trial. Their evidence, their claims, their logic. And if they can't support it, it should be tossed out. That's the way it's supposed to work. And we're bringing out, of course, that it doesn't. That they're not doing the right thing. They're not being fair. They never had any intention of holding the prosecution to their burden of proof. Well, they don't have to prove that. Oh, again, someone please show where I or anybody else can make the foundational legal claim of their defense that sets the relevance for the entire defense and do so with no evidence. Where is the where are we as the defense given the same privilege as the prosecution? If you don't get to do that, it's not fair. And then to say that you can't even challenge it, that it's irrefutable, again, unfair. So do not lay the burden on him that is questioning your claim. If you make the claim, you bear the burden of proof. And one of my favorite lines from A Few Good Men, this is something that is sorely lost on lawyers and bureaucrats. And it should be a part of their oath. Well, not that way. That would matter. But near about 2/3 of the way through or more into the movie, Lieutenant Caffey says, "It doesn't matter what I believe. It only matters what I can prove." Yeah. Yes. See, that's a difference between honest people and YouTube trolls and whatnot, and people who say, I've never had any success. It doesn't matter what I believe. It only matters what I can prove. That's why the 10 Commandments of logic are so damn important. We have 2 more of the commandments to get to, and they're pretty good. Pretty good. So we'll be back with your calls in just a few moments. We're at the top of the hour break, so we got about 5 or 6 minutes for those who are on the YouTube stream. But that's 218-632-9399. And the passcode is 2020 with the pound sign. We'll get you into the chat. Well, get you onto the show. Yes, welcome back. It's the second of 3 hours of Anarchy Radio right here on LRN.FM and streaming live from my YouTube channel. No State Project. The number is 218-632-9399. The passcode is 2020. Gets you into the queue for the big show. I want to finish. I was talking about the 10 Commandments of logic before. And very important because most people are full of crap. And even if they're not using the basic principles of logic and using the Socratic method, keep the burden of proof on them. So the last thing we were talking about, thou shalt not lay the burden of proof onto him that is questioning the claim, and it quoted one of my favorite movies. So for those who may have missed it, these should be words to live by, especially, look, it doesn't matter what I believe. It only matters what I can prove. So that's why it's so important to question people on these things. Keep the burden of proof where it belongs because that's where it's going to be most effective. If someone is saying X equals Y, why do they believe that that's true? Question them on it. And if you're talking to someone who is a government apologist who thinks that government is legitimate and that their rules called laws actually apply to people, those are claims that they're making. The burden belongs, it's on their shoulders to prove that that's true. You know, so it's like, I don't care what you believe right now, sir. I only care about what you can prove. And so Hitchens' razor, Christopher Hitchens, I disagree with this man on many things. His support for the George Bush was, how could a guy who said that which can be asserted without evidence can be dismissed without evidence actually buy into the Iraq War invasion, support George Bush the way he did? I don't know, but that doesn't take away, and you're not going to throw the baby out with the bathwater. I may have disagreed with him on many things, but on this one, he was dead on the money. That which can be asserted without evidence can be dismissed without evidence. However, when we're in court, it's a little more dicey because we're dealing with people who don't think evidence is important. Oh, wait, I shouldn't, no, I generalized there. They only think the evidence is important when you are accusing them of something. If they accuse me or you of something, evidence be damned. I don't need evidence. Imagine for a moment you go to sue a judge and they start arguing a lack of jurisdiction. No, I don't need jurisdiction. You guys have jurisdiction over every complaint that's filed. See, the smart thing, I guess, would be to do if you want to file against a judge, file it into traffic court. File it into a justice court. These crooks think that they have jurisdiction over literally every complaint that's filed in front of them. Oh, yeah, and that's not actually true. They think they have jurisdiction over every complaint filed by another government agency. I love how they exist. Subject matter jurisdiction means they have jurisdiction over every complaint of a certain subject matter. Not even remotely true. Okay, so let's get back because we got callers lining up. Thou shalt not assume this follows that, where there is no logical connection. Non sequitur. If you're physically in Arizona, the laws apply. This does not follow that. There is no logical connection between the two. A lot of people may think that, which is actually the last one of our 10 commandments of logic, but I'll get to that. Thou shalt not assume this follows that. So, man, that is so common. Well, if you're physically here in court, we must have jurisdiction. Well, you filed returns for all these years, so you must have realized that you are required to do it. See? This does not follow that. Non sequitur. They said, well, the only evidence we need of jurisdiction is that you filed a return. Oh, so it follows then, sir, and this is your leading question, so it follows by your logic that if I don't file a return, you don't have any evidence of jurisdiction over me, do you? Well, we could still file a return for you. So doesn't that defeat your logic that the evidence of jurisdiction is my return? See, this doesn't follow that. It has to logically follow from that. The laws apply as a matter of law. Does that logically follow? I mean, is that sound logic? Or is that stupidity? Is that just gross stupidity in action? Well, the laws don't require evidence to apply. They just do because they're laws. Why do you think that's true? Aren't laws just the written will of the legislature? That's a direct quote, by the way. I mean, you can verify this by, you can see video. You know, you have the legislature, you know, they like Congress, and they write something up and they take a vote. And then the president signs it, or it's overridden by they override it with a vote. They override his veto, or he doesn't sign it. So it's just the written will of men and women called Congress or the legislature. How does it follow? Well, this does not follow that. Keep that in mind. It's not logical. If they want to turn around and say it's legalistic gibberish, it's proper English, Mark. It's not gibberish in English, but in the legal field, in our mind, in this context, it is gibberish. Oh my. Anyway. It still comes down to, does this follow that? Does this logically lead to that? Does this cause that? Remember the false cause that we talked about before? Does this follow that? Well, you have a driver's license. There must be jurisdiction. Really? Is that logical? You're here physically in Arizona. So you see how this does not follow that. You have to critically analyze the claim that is being made. Keep the burden on the one who's making it and ask them these questions. Really, why do you believe that just because I have a driver's license, there is jurisdiction over me? Why else would you have the driver's license? Well, it's compulsory, isn't it? Don't you get the driver's license to avoid being molested on the street and possibly being killed? Doesn't the Constitution and Code have to apply and create the obligation to get the driver's license? Isn't that how logic is supposed to work? It's legal logic. Is it illogical? Can you prove it outside of a courtroom? Can you prove it outside of a judge saying and agreeing with you? Can you actually prove it? Again, it doesn't matter what I believe. It only matters what I can prove. So just like with the motion to dismiss in Wisconsin being granted, I can prove it was granted. Can you prove that the judge did it for some other reason? No. It doesn't matter what I believe. It doesn't matter what you believe. It only matters what you can prove. And last but not least, of course, as I touched on this in the last one, thou shalt not argue that because a premise is popular, therefore it must be true. But Mark, all these judges disagree with you. So what? That does not in and of itself mean the judges are true. Break the argument down. See if the premises logically lead to the conclusion. And if the evidence and the logic doesn't support the conclusion, it doesn't matter how many judges agree. Oh, there's 1 billion Catholics in the world, or damn near. I guess Catholicism must be true. But wait, there's almost 1 billion Muslims in the world. How do you, oh my. It doesn't matter how popular the opinion is. It doesn't matter who holds the opinion. It doesn't matter if they're a judge, if they gave themselves these stupid titles of honorable. Does it stand up on its own, independent of who's making the claim? That's what matters. That's what's really important here. So just because a judge a judge disagree. You know, judges have disagreed that Brady violations require a dismissal. Judges have disagreed that a Fourth Amendment violation or even a Fifth Amendment violation warrants a dismissal. Doesn't mean that they're right. I had a judge in Phoenix say there's no right of cross-examination in traffic court. Is he right? Well, I guess we've got to comply with that until it gets changed. I don't think so. Those are our 10 commandments of logic, and we'll continue discussing them on the show throughout and how they apply in a political or in a court setting. We'll be back with your calls in just a few moments, so don't go away. And it's 218-632-9399. Passcode is 2020 and the pound sign. Yes, welcome back to the No State Project. Streaming live on my YouTube channel, No State Project. And also, of course, originating from the Liberty Radio Network, LRN.FM, baby. Glad to be with you here. If you want to join me on the big show, 218-632-9399. The passcode is 2020 with the hashtag. And Skype, as always, is Frank Rizzo 3. So I want to remind everybody about International Shoe versus State of Washington. And this is a Supreme Court case. It's based, some things based on Milliken versus Meyer, some standard things. And so when let's see, that's where I was quoting, if I could spell. Hold on. See, where you have like Milliken versus Meyer, which is 311 U.S. 457, and the quote is on 463, has to do with a court taking jurisdiction may not offend traditional notions of fair play and substantial justice. And it's a lot of cases that they are supporting that. Like, I mean, it's just a basic principle that is thrown out the damn window when it comes to attacks on us by government. And, of course, men and women who just force us to pay them. There you have it. Traditional notions of fair play and substantial justice. If it's illogical, if it is literally because you say so and are willing to hurt me, that offends traditional notions of fair play and substantial justice. Because if it doesn't offend traditional notions of fair play, then I should be able to counter that violence to neutralize the act of jurisdiction, and that would be considered, fair, part of the fair play. And it's not. That's not the way they see it. So I want to go another new caller. So we've got area code 720. You're live on the big show. What's your name? Where are you calling from?
Hey, how you doing, Mark? My name is Brendan. I'm calling from Colorado.
Brendan. All right. What do you got for us today?
I have a question with regards to, I'm dealing with a criminal DUI case right now. And I'm trying to figure out what I need to do to take care of it. So far, I've been reading on e-concurrent. I'm pretty sure you're familiar with that. That's Patrick Devine's work. I've been reading about using the public defender, accepting their oaths and their bonds for value, and then essentially relieving them of the ability to collect the debt. So I was wondering if you had any advice, how I should go about this, how I should fight it. Is there any specific laws I should cite? What type of process should I use?
Have you actually questioned?
Right now,
have you sat down and investigated and analyzed these claims that are being made to determine if they are true? And if they are true, have they actually been effective in court?
You're referring to the claims against me with regards to the DUI, right?
No, I'm talking about the claims that you're making about how to defend against this, to relieve the debt and whatnot.
No, I have not. I've just been reading Patrick Devine's work and the creditors and bonds section. That's where I haven't done it yet, but
good.
I do know this, that I went to court and I slipped that judge a note through the clerk, and because I didn't want to put the whole courtroom on blast. And I told that judge, I said, look, I'm fully aware of your state banker capacity. I know you're here to collect a debt. I'm here to settle that debt. And then I went into, I authorize you to blah, 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 so on and so forth. Now, that judge apparently is afraid of something, because that judge came out from their chambers just for me. Everybody else was in the courtroom too, and called my name, and I stood up and began to say obviously that's not who I am. But the judge interrupted me and said, let me finish. Quickly set my court date over 2 months, and then turned the record off and moved very quickly out of that courtroom with everybody still in the courtroom. So that judge is afraid of something.
Well,
now, I'm pretty sure it's for me to put that judge. I'm pretty sure that judge is afraid that I'm going to put him in dishonor.
Oh,
I'm going to use that dishonor.
You're using all the buzzwords here. Okay, why do you?
What?
You're using all the commercial buzzwords. Why do you believe that the state judge is acting as a state banker to collect a debt?
Because that's just what I've been taught. And I understand that
you read it.
This is a debt. Like, there's an index. Like, these are indexed.
Wait.
Okay, like there is an index. My friend has the index, a copy of it. Now the index holds. It says that your charges are associated with an actual fine. Now, that fine is not published publicly. I mean, it's how much they're going to bond the matter for and then sell it as.
Okay, so, wait. Let's slow down here a second.
Go ahead, sir.
Okay, because so you haven't done an investigation to critically analyze the claims that are being made that the judge is actually acting as a banker. Now, the typical response that I'll get for someone is that, Mark, they use the words "and bank," BANC, when they're talking about like an appellate court or that's not the same thing as banking, though. So you have no evidence to support the claim that the judge is acting as a banker, right?
I mean, other than the fact that, I mean, there's a debt associated with that charge. I mean,
but someone can, just because somebody and we'll get to the debt in a second. Just because there is a debt involved doesn't mean that you're working with a banker. You could be working, like, say, the Michael Scott law firm or a credit card company. Doesn't mean you're working for a banker, right? So you have no evidence the judge is actually acting as a banker.
No, that's more based on just what me and the people that, myself and the people that I associate with believe.
All right, so you remember what I said? Did you hear the part that I said at the beginning, quoting from A Few Good Men? It doesn't matter what I believe, it only matters what I can prove.
Correct. No, I'm fully aware.
All right, you should have that a sign or have it on your computer, and those are words to live by. Do no harm, and it doesn't matter what the hell I believe, it only matters what I can prove. So what evidence do you have that that would suggest or prove that the judge is trying to collect on a debt?
That other than that index, none.
Where is this index? What is the source of this index?
I'm not exactly sure. It comes out of their actual like the book, that they give to either the DAs. It was a photocopy from the pages of one of the books that have made its way out there. Now this one. Okay. All right. Well, we're up against.
Wait. Hold on. We're up against a break, Brendan. We got plenty of time to flesh this out. You're crashing and burning so far, but I think it's good to demonstrate that why you shouldn't be using this stuff. So just hold tight. My name is Mark Stevens. You're listening to the No State Project here on LRN.FM, using the Socratic method on both sides of the fence, so to speak. So it doesn't matter what the claim is. Question, question, question. We'll be right back. Welcome back to the No State Project here on the Liberty Radio Network, LRN.FM. And streaming live, of course, from my YouTube channel, No State Project. Because when you look at the facts, when you look at the logic, when you hold them to their burden of proof, those claiming that there is a state will not be able to prove it. There's no evidence. The evidence is dead set against it. And you just have to ask some questions. And what we're doing now, whether it's a government apologist or somebody who's on the internet who goes around talking about ways to get things tossed out of court, these things come up all too often, unfortunately. Even the last show came up again. This stuff has no merit, and as we're talking with Brendan in Colorado, the least that we're showing here is that Brendan is not prepared to take this to court and defend using this because he hasn't done any investigation. And on just asking a few questions, this stuff falls apart pretty quickly. So, Brendan, getting back to this, you're saying that somebody took a copy of one page of a book that is of... Does anybody know... Does anybody know what book that is, and if you can get a copy of the entire book? I mean, what's the name of the book?
Sure I can. It's pretty sure it's the DA's handbook. Now, I'll see if I can get that to you. If you can get me somewhere to send it, I will be more than happy to share with you what I have. Also, I have another question for you. So with regards to e-concurrence suggestions on how to handle this and using the public defender and accepting everything for value and getting them to accept it that way. It's an A for V process. So you said, what evidence do I have to support that, right? So you create the evidence through the process. And then when you get into court eventually, this is what he's suggesting, Patrick Devine, that you use the public defender to present it, and he gives you essentially you file a lien. You relieve them of the ability to collect the debt, and in return, you can. Essentially, you file. It's a certain type of lien. I wish I had the name in front of me. You file a lien against them as well, which overturns the lien that they have, overpowers the lien that they currently have on me or you.
All right. Okay. There's so much going on here. Wow. When you talk about bonds, are you talking about bonds that the state employees and city and county employees, their bonds?
Yes, sir.
Well,
Yes, I'm talking about their official bond.
Okay. This Patrick Devine guy, I think it's interesting. His last name is Devine. Did he bother telling you that for decades they do not have bonds anymore, that they cities, counties, and states, they self-insure?
So how are they so they self-insure, but they're still required to insure themselves, right?
Yes, but they don't have bonds like they did 50, 60, or 100 years ago. They self-insure to cover.
Okay.
So,
well, I understand that. I always thought that could have been my mistake. I always thought it was to be a bond.
It used to be.
Yeah. So they have an insurance policy, and then they have their oaths.
Yes. However, this idea that you can file a lien against them, I got to tell you, I got to agree with Al on this one. Well, I agree with Al on a lot of things. And no, it's my favorite quote from you, Al. No. Anyway, do you have evidence to show that they have a lien against you? So I want to see, where's the evidence that they're collecting a debt? And this is prior to even being found guilty, apparently. What evidence do you have?
They're not. Are you telling me that they are not there to collect a debt? Is that what you're saying?
Well, I'm asking you to. You're saying that they are there to collect a debt.
Right.
I'm asking you for evidence of your
Correct.
claim.
I'm sure that I can get it. I don't have it right in front of me, no, but I can find it. But are you sitting here also telling me, in response to that, I guess I'm asking you, do you think that they're collecting a debt or not? Is that what they're doing? Is that what they're there to do? Compel me to provide a certain service or to fulfill a payment plan or anything like that. Are you saying that that is not the case or is the case?
I think prior to a conviction, that is not the case. And so my other question here
So I'm
is,
not in breach of contract. So you're saying I'm not in breach of contract because I said I understood the charges, correct? And then that means, from what I'm getting and from what I've gathered and from what I've studied, it states that I'm letting them know that I understand this is a debt and that I need to pay it. When you do not pay that debt right then and there, and you say you understand, then you are in breach of contract. And then you go into pleading, which is you're trying to figure out the payment plan.
Brendan, there's 4 factual elements necessary for a contract. Could you please tell me why you believe that they're trying to contract with you? What factual elements are present that would lead you to believe that they're contracting?
I understand what you're saying. I think that it's fraud, personally. I think that it's fraudulent.
Sure.
I think that they go. I mean, it is fraudulent. Everything that they're doing is essentially fraud.
Yeah. Yeah, but I'm trying to. But in knowing that, it helps to know that to then be able to craft an effective defense. And I don't think you've done that so far. So you said that there's a lien.
No, sir, I haven't.
You said that there's and I want to make sure that you are, if you're going to defend yourself, you're going to do so rationally and effectively. So we got to dispel some of these other things here. That's why it's great you called after I did, the first hour of the show talking about the 10 commandments of logic, because you did. All right. So do you have any evidence that would show that they have a lien against you prior to a judgment?
No, that's what I do not have any evidence for that.
So you're assuming that?
Yes, sir. Mm-hmm.
I tell you, what I have been able to do for these years, and people have been able to replicate many, many, many times, is to just attack the actual claims that they're making against you, because there isn't a shred of, because you're right about fraud. It's violence and it's fraud. They're lying. They're criminals. So our defense should be limited, I think, and because we've proven time and time again, if we limit our defense just to attacking the claims that they're making, that's been sufficient, because they can't support their claims. The claim that they're making, and there's no dispute to this. You ask them, they'll tell you. I know they lie, but they'll tell you this is exactly how they're operating. They saw you in Colorado. They determined the Constitution applies and gave them jurisdiction and probable cause to arrest you or give you or write you a ticket. And they believe that again gives the court personal jurisdiction and subject matter jurisdiction. Those claims that they will admit and shout from the rooftop. That's how they're doing it. Mm-hmm. And I've been able to show a pretty good track record on my website where the motion was granted, prosecution has withdrawn. When they are put on the spot to provide the evidence that we're asking for or we say is missing, they withdraw. So we have direct evidence to actually prove the motives of the prosecutor and judge. Because they cannot produce a shred of evidence. There's no logic, there's no rationale, there's no evidence, there's no qualified witness to support that claim against you. So they can't prove territorial, personal, or subject matter jurisdiction. It's also an element of the charge because they're accusing you of violating their code where it's only an offense because of the code. So if they can't prove that the code applies,
correct,
how can they prove beyond a reasonable doubt that you violated it?
Fair enough.
And that is, and so without going into court, if we're just discussing this, it passes the logic test. It's sound logic. And when we do look at what's happened in court, I can show you success that was replicated on 3 continents. Now, some of them just had to do with the fact that the prosecutor just didn't want to do it. I'll grant you, but most of them aren't explained that way. But we'll continue in the next segment. My name is Mark Stevens, talking with Brendan in Colorado. Why logic and reason is so important. We're defending ourselves, and we'll be back in just a few moments. Yes, welcome back to the No State Project here on LRN.FM and streaming live. Jeez. Streaming live on my YouTube channel, No State Project. And, yeah, I don't know. There's something up with YouTube today. But I'm probably going to delete all, the live stream. And what I'll do is I'll just, with some graphics, I'll upload the good audio after the big show today. So look for that. Glad to be with you here. I'm not going to give out the caller number right now because we are loaded up with calls. I want to get back to Brendan in Colorado. Now, you haven't filed any of this stuff yet in defense of this charge, right?
No. Yeah. I've just served. I've served my secure party documents that I did through the redemption manual. I served that on the court, and that's it.
Oh man, they could just.
Yeah.
They're going to label you a sovereign citizen and a domestic terrorist.
Okay.
So hopefully they're not going to do that. And hopefully, you're not doing anything like filing a lien against them because that.
No, I can't. You can't do that anymore. You have to go through their in the state that I'm in. Colorado said we can't file liens on state officials anymore. That we have to go through the Attorney General's office, file a complaint, go through their administrative process first, and get them to file a lien. Now that was a change in the UCC, so I assume that it's nationwide. So that's no more. That's no more.
I don't know why the UCC is involved with that, but I guess I can. It's always a bad move to do it anyway. You're not going to hold. There's something that we have to acknowledge right now. For the present time being, we are not going to hold personally accountable judges. End of discussion. It's not happening. Okay. There has to be some social change to where we could do something like that. The best I think we're going to be able to do is to go after the insurance, the risk management, and file against the insurance policy. It's not going to be personally against the judge, but at least you have at least the theoretical or the possibility of getting the judge into. So if you sue the insurance, for the against the policy, and you get it into court, then it's possible you can get the judge and the prosecutor into a deposition where you otherwise could never do that. And then using their statements, their own admissions that there was no evidence, because you'd be able to look the judge dead in the eye and say, sir, what evidence did you rely on from the prosecution to prove that your Constitution applies and gave you jurisdiction to hold me? He's got to put up. But it's theoretical at this point because we've never done it before. It doesn't mean it'll never happen, but that's the remedy there. So this whole thing about liens, I would From now on, whoever is saying it, it's like with me too. It doesn't matter what I believe. It only matters what I can prove. So can I prove that asking questions is very effective? Yeah, I have the proof on my website where you can hear them admit that they had no evidence. You can hear a law professor admitting the obvious, that jurisdiction is a blunt assertion of power. It's not based on argument or evidence. It's so when you said fraud, yeah, they are criminals. So the effective way to deal with them is logically, because they don't hold themselves out as a criminal enterprise. They hold themselves out as a legitimate organization administering justice. And because the ends conflict with the means, we're going to bring out that contradiction that it's all based on force. A blunt assertion of power, no, that does not square with their own code. So that's why we do that. So we take the claim that and it's the prosecution's burden, not the judges. So for those who are new, remember, this is trying to drive a wedge between the judge and the prosecutor. The prosecutor has the burden of proof on jurisdiction, not the judge. The judge is responsible to make a decision based on the prosecution's evidence. Does the prosecution have sufficient facts to show that there's personal jurisdiction? Well, personal jurisdiction is based on if he's physically in Colorado, then the laws apply. Does the prosecution have any evidence to support that claim?
Do they? I'm not sure. I need to ask that.
Yeah, but that's where you should be focusing your attention. Not on this Patrick Devine stuff of getting all these accepted for value garbage and where you have no evidence of a debt. That if it's after the trial and you've been convicted and they hit you with a fine, that fine may be considered a debt. Sure, they may actually do a lien, but it's not too common. I don't know.
Now, because what if I accept state benefits? Is that proof enough that I'm bound underneath their constitution, bound to their code?
What state benefits are you receiving?
Medicaid right now.
Yeah, you got a problem with the federal. You got a problem raising that. You can still, Medicaid was it compulsory?
Was it compulsory?
Yeah.
Yeah.
Well, if the benefit, like a driver's license, is compulsory, then it's really no evidence to prove the Constitution and code apply, and it would be kind of. I would really like to know if they would actually hit somebody where they could say, you don't have standing to challenge personal jurisdiction because of this benefit over here. And let's just say that they say, all right, you don't have any standing to challenge personal jurisdiction. Let's give them that for sake of argument and discussion. Personal jurisdiction can be waived. It can be. Subject matter jurisdiction cannot be waived. And so since the evidence has to be there for subject matter jurisdiction, yes, jurisdiction requires evidence. Subject matter jurisdiction is based on it being a justiciable case or controversy before the court. That the court, being that it's an adversarial proceeding, an adversarial system, has to have two true adversaries. Having true adversaries doesn't mean just because people disagree with each other. Being a true adversary means one of the parties, the plaintiff, at least one of the parties, the plaintiff, for example, is making an antagonistic assertion of rights. They're saying that their legal rights were violated and that the damage was caused from it. That's what makes somebody, under American angle of law, makes them a legitimate plaintiff with standing to complain. That is what gives the court jurisdiction.
Okay, talking about, is there a damaged party, essentially? And
yeah.
They're claiming to be the damaged party.
Yeah.
I mean...
Right, that's the backbone.
I didn't damage anything, I mean,
right. So the thing is, there has to be proof. You can't just allege a corpus delicti. You have to have evidence to support it. So with them, they're accusing you of violating the code. They have to have personal knowledge. They have to have evidence to prove beyond a reasonable doubt that the code applies. They can't just. They may not assume that. They want to assume that. Oh yeah, but they don't have that. Now you could go back into the prima facie and say, does the evidence have the facts? Do the facts as alleged, your physical presence in Colorado, do those facts have any chance at all of proving the Constitution apply to you? Any chance?
Okay.
Now I don't think that smart people, even critics who have been on the show, will admit that it doesn't. I've had people on and off the air, mostly off the air, bureaucrats and whatnot, that physical presence in Colorado is in no way proof that a written instrument called the Constitution applies to you. So it's not even prima facie evidence that they can use for subject matter jurisdiction. And because they don't have nearly enough evidence, not even a prima facie showing for subject matter jurisdiction, it doesn't matter. That can't be waived, and it has to be tossed out. It is not enough to just make the allegation. You have to have some facts that will create the prima facie, to meet that prima facie burden that will then create a rebuttable presumption, and they don't have it.
Okay. So what you're saying I should do essentially is challenge them on the jurisdictional basis that, get them to prove jurisdiction. I mean, get them to prove that their Constitution does apply to me just from me physically being here. Now, what you said about the Medicaid, does that also apply to whether or not I have a state ID?
Well, the state ID is usually compulsory.
Fair enough. Yeah, right. That's why. So everything with regards to identification or anything like that, I mean, it's all compulsory.
Yeah. Well, let me ask you this. If you, let's say you're the one making the allegation, and you're saying that the state ID is evidence proving jurisdiction. So you want to ask him questions. Let me see if I understand you correctly here, tough guy. My having a state ID is evidence proving the Constitution and laws apply to me, which gives you jurisdiction over me. Now, from there, it's just asking, we're up against a break, and we'll cover this, we'll repeat it when we get back, is asking them how that works. But let me mute you up. We'll finish in the next segment. My name is Mark Stevens. We'll be back at the top of the hour for the third and final hour of Anarchy Radio right here on the Liberty Radio Network, LRN.FM. We'll be back in just a few minutes. Don't go away. Yes, welcome back to the No State Project. I'm Mark Stevens, third of 3 hours of Anarchy Radio right here on the Liberty Radio Network. And anarchy meaning an absence of rulers. Those who would rule us, not an absence of rules. And the rule being, do no harm. Live honestly, injure no one, give every man his due. Something we all can understand and accept. And what I'm gonna do is we got a lot of callers. So I am going to mute up the feed. So we're going to blow through all the commercials. So we'll get a bit more content. So that's why we make sure we get to everybody that wants to get on the big show. I will be live on the Wednesday commercial-free broadcast, but we'll do what we can. So if we do miss somebody, we'll get with you there. So we're talking with Brendan in Colorado, hopefully saving you an awful lot of heartache and getting you on the right path to effectively defend yourself on. So when somebody asks you why you're doing a certain thing, what's the logic and how is it, has there been success in the past, you can say, well, yes, here's the logic, these are the facts, and you can answer the questions, and it has been replicated because here's the documentary proof, and you can send them to markstevens.net. We have it under the success stories that they can see. Unlike, when you start going through this Patrick Devine stuff, it every time I asked you a question, this crap broke down, which it should, because it just doesn't withstand the scrutiny. So we're asking about the driver's license, and I was just using that as an example. If somebody was to say that the driver's license or a state ID was evidence proving jurisdiction, you want to get them to confirm their position before you start asking some questions about that, okay? So the question that you can ask is, let me see if I understand you correctly. You're saying that this ID card that I got is evidence proving your laws apply and that there's jurisdiction. Yeah, of course. And then, okay, so this driver's license or this ID card is actually proof and proves your Constitution applies to me. Can you explain exactly how getting an ID card proves the Constitution applies? And then just sit back and let them stutter. I had him unmuted. Okay. Yeah, there he is. I'm sorry. I must have got muted again. But so do you see? Can you see the logic there? Why that would be effective? Just put the burden on them to prove if that is evidence of jurisdiction. What they're actually saying to you is, this is proof that the Constitution applies and gives me jurisdiction over you. So then you just ask them exactly how does that work? How does getting a driver's license or an ID, how does that prove the Constitution applies?
I do understand.
Okay,
I understand where you're going with that.
And I've asked them, I have call of shames. I know it's been a while. It's getting really tough to get these people to talk to me now. But I do have call of shames where you can hear me discussing that with actual bureaucrats, and so you can hear their responses. And in no instance have they been able to give an articulate a lucid argument to explain how getting a driver's license proves the Constitution applies to you.
Now, is there anything do you think they would respond with that would provide grounds for their accusations? I mean, is there something they could say to, like you're telling me that they can't make an argument? I mean, that's when you're talking about jurisdiction and the Constitution applying to us. So, is there anything they could come back with?
No. The only thing that there's nothing. There's no evidence that's responsive. There's no facts that actually prove that, because that's ridiculous. It's a non sequitur. Especially you don't even have to put the compulsory nature into it. It's illogical and it doesn't follow. The one doesn't prove the other. The Constitution would have to apply and create the obligation for you to then get the driver's license, not the other way around. That's just stupid. Right. We're going to force you to get this driver's license so we have jurisdiction.
Well, and if it did, and plus it would have, like you said, there's 4 elements to a contract. Essentially, that would be me contracting with the state, and they would have to inform me of all that before I got an ID.
If it was a contract, yes. If it was an actual contract, there would have to be a freely given agreement, a meeting of the minds. They'd have to give you all the details and the implications of getting it and not getting it. And because it's compulsory, there's no meeting of the minds. And there's no evidence. And the reason why they can't show that their laws apply is because the evidence is dead set against it, because they're just men and women forcing us to pay them. Forcing someone to give you money doesn't create an obligation of allegiance and protection, which is necessary.
Right.
Even for a resident, they assume that they have a duty of allegiance, which because they are alleging that the resident is subject to is entitled to their protection. Which someone brought up a really good point, and I didn't. About the police officer in the Parkland shooting. He's being sued, and he's arguing that he wasn't obligated to run in and say, and protect those children. His job as a security was to literally protect children. Didn't do it. Now he's arguing he doesn't have to do that because forcing people to pay you makes you a criminal. It doesn't make you legitimate, valid, and it doesn't create obligations of protection and allegiance. So that's why they can't prove that. Okay. Plus, how would a written instrument?
Now, if they came, go ahead.
I was just saying, a written instrument does not apply to someone just because they're in a certain physical location. Just because I'm physically located in Sun Devil Stadium does not mean that the rules of professional football apply to me.
Agreed.
It's the same thing here.
Okay. Now, what if they came at me with the fact that I'm a United States citizen? Again, that's compulsory because I was born here. I don't question that.
Yeah, but that claim that you're a citizen, if they're going to make the claim, they have to prove it. The burden of proof is on them. So, what I'd say is, I ask a leading question here. Isn't whether or not I'm a citizen dependent on your original claim that just because I'm physically in the United States, your laws apply? It's the same claim. They're claiming their claim is that because I was physically in New York, their laws apply to me. It's the same claim. Okay, let's break that down.
And then that falls back down to the Medicaid as well. They can't. For me to accept Medicaid, they would have, and for that to bind me to their laws, they would have had to have told me that. They never said that. Oh, by you accepting benefits, we have jurisdiction over you.
They believe that.
They never stated that anyway.
Right, but they believe that if you look in their court cases. I used to talk about that all the time. That, in fact, International Shoe is one of those cases where they're looking at having a nexus with the foreign state. So that even if they're not physically in the foreign state, if they have certain connections or they've done some even transitory business, They want to know, has the state given something for which you can ask a return as far as taxation? And they're saying also for jurisdiction. I look at but you can't look at it in a vacuum. It's like when somebody wants to say, well, the Supreme Court has ruled that the jurisdiction is satisfied even if they literally kidnap you from overseas. But the same the same Supreme Court ruled that taking jurisdiction may not offend traditional notions of fair play and substantial justice. So the thing is, does literally kidnapping you, offend traditional notions of fair play and substantial justice? I believe it does, and I think here,
of course, yeah,
you want to use the same, the same principle applies. Is the taking a jurisdiction, does it offend traditional notions of fair play and substantial justice? I believe in most instances it does, especially if not all, because you're looking at it where a group of men and women who are forcing people to pay them. You're talking about a criminal organization. But I would, if I were, in your shoes, I would file the motion to dismiss and discovery request, and I would not even, if the other crap came up, sir, I was misled. Please, if we could just strike that from the record or disregard it completely, I'd rather just stick to the matter at hand. I have a motion to dismiss pending where the prosecution has failed to present sufficient facts to make a prima facie showing and cannot, under any circumstances, prove the charges beyond a reasonable doubt, and it should be dismissed. I'd stick with that.
Okay.
And hold them to their burden.
And basically everything that we spoke about, I mean, I need to. So first, I have a public defender. So do I need to fire him?
Well,
to be able to do that, or can I can I get him to do that since he has an oath to uphold me and the Constitution?
Well, he doesn't have I don't know if he has an oath to uphold you. He's supposed to, his job is to defend you and ensure that through objections and paperwork that you are getting a fair trial. His job is not to acquit you. His job is to ensure that you're treated fairly. Given what you've told me so far,
this would fall underneath there. I mean, based on what you're saying.
Well, but the thing is, he doesn't have to defend you in the way you want to be defended. What I would suggest here, given what you've told me already, you need a lot of work. You're not ready to defend yourself. What I would do is I would start learning the basic principles of logic, learn your objections, learn court procedure, which I have all on my website too, and we have. No State Project Skype chat that can help you because I have a script and you can do role playing to help you really hone your skills on how to effectively, question people and hold them to their burden of proof. You probably want to look into, at least for the time being, having the attorney be standby so that both of you can argue on your behalf and offer objections and question witnesses if it gets down to that. You're just not in a place to do it yourself.
No, I completely agree with you. So if I wrote all this up and proposed this to the attorney, what do you think he might say?
He's going to tell you, I'm not putting my name on that. Not putting my job on the line for you. You're not that important of a client. Or he's just not that into you. So he can be standby, but if he's standby, he can help you through the process. And again, he can make objections. And he can offer argument. He can cross-examine and so he can do all that with you. But this allows you to file the paperwork and argue it and raise your own objections. Okay?
Right. And defend myself. Okay. All right. Well, I really appreciate your time.
Not a problem. Stay in touch. I do have at markstevens.net. I do have available the templates for that and the script. So you can get that there. And I'm Frank Rizzo 3 on Skype, so you can get into the Skype chat and start learning how to effectively defend yourself and do through the role playing.
Awesome. Hey, thanks, Mark.
Appreciate the call. That Brendan in Colorado. I also recommend not just the role playing, but going into the city council meetings or county commissioners. It's better than doing it on the phone because you're in person, you're in a court, you're not in a courthouse, but you're in a government building. And you can ask the same kind of questions and hone your skills on how to effectively hold them to their burden of proof. And one of the questions is, look, I know that you guys operate under the presumption that if I'm physically in Colorado, your laws apply and give you jurisdiction over me. Yeah. Do you have any facts that would prove that that's true? Any facts? Any evidence to prove that your assertion is true? And remember, you're not in court, so you don't have to listen to this garbage, this nonsense that only judges can say the laws apply. Only judges can make judicial determinations that the laws apply. But then there's also the fact that juries can too. The juries are jurors of the law and fact. So the judge, if there's a jury, is not the only one who makes such a determination, the ultimate determination. But bureaucrats, when you go into a city council meeting, are going to make that determination. They're going to verify that that's how they operate. And you want to know if they have any evidence to prove it's true. So definitely do that so that you can deal with the trash that's going to start spewing out of their mouth about that. All right, we got another new caller I want to get to. We got area code 716. You're live on the No State Project. What's your name? Where are you calling from?
Yes. Hey, Mark, this is Shane up in New York. How you doing today?
I'm doing well.
Just wanted to see if you got my email I sent you last week.
I get a lot of emails. It doesn't ring a bell. Well, just tell me what was in it.
It was regarding the motion for discovery and the motion for eliminate. The documents that I talked about a couple weeks ago, the DA answered it. I am not going to talk about what he said over the phone. It was unbelievable.
Oh.
I'd like to scan it and email it to you and maybe have a private consultation with you, but it was startling.
It's startling to a point where you won't discuss it on the air.
He wants a complete psych evaluation. I mean, it was just incredible what I saw. And he would not release his name or anything.
He wouldn't release his name? You don't?
Nope.
So,
no, you're not. He says, I want to know your name. He says, you're not getting my name. All the documents has initials on it. And the judge said that he really should be giving his name out to you. And he left the courtroom.
The judge agreed that he should have provided his name?
Yep.
Doesn't the judge know his name?
Yes.
Well, couldn't you have just gotten his name from the judge?
No, he said you need to get it from him.
Come on,
unbelievable. I would like to, off the record, I'd like to talk to him if I could, and, like to email this to you. Wait till you see this. This is incredible.
Wow. For some reason, my stream is not getting the audio. It's all being recorded, everybody. I'm sure it's fine on LRN.FM. It's just there's an issue with YouTube today. What he's saying is the prosecutor will only give initials, will not give his full name. He's looking for a full psychological evaluation. And the judge was being a douche and wouldn't give him his name. Where is this happening? Can you tell me the town?
Yes, it's in upstate New York, town of Evans.
Evans?
Yes.
And it's a man that's doing this.
Yes, sir.
And his initials are?
He has SS, sir.
SS?
Yeah.
Yeah, is that a coincidence?
I don't know.
It's
crazy. Wait till you see this.
I apologize. Maybe because of an attachment, it went to a spam folder, and I didn't see it. But I will go back and check. I can't check now because I have to shut my email because I can't turn the damn notifications off, and you hear all that throughout the show. Anyway, I will check that out. If I don't, I will have to. You know what? Why don't you email me at markstevens@mail.com. And
okay.
Or you can drop it in Skype.
Mark, yeah. Oh, okay. Hey, Mark, before you leave, real quick, I just want to let you know that I did put my subject line New York, and I put my name on there, and I sent it to you about exactly a week ago. From right after the show, I sent it to you.
Okay. I don't remember it. I'd remember this, so it may have gone to spam. So I will check that. But you don't have to go just yet. This is horrifying. I don't want anyone to. I just want to give people a heads up that I have over 20 years, and I've been just doing the show for 10. The hundreds and hundreds and hundreds, maybe a few thousand people that I've worked with over these 2 decades, less than 10 have had something like this threatened. Now, we went through the nightmare with Bao. What happened with him? He asked a question in court, and the judge decided that it was going to be a 10-day sentence in jail and a psychological evaluation. So, did the judge actually say anything in court that he was leaning towards granting this prosecution's request for a psych eval?
No, that I just got the answer 2 days ago. Nothing like that. The next court date is not for another month.
Okay, so the judge is not taking it serious, apparently. So
No.
That's good to know.
No.
I certainly now I don't want to look. This is totally up to you. I would like to call. Is the attorney working for the city of Evans or is it for the county? Is he a county? Which one is it?
County. It's for the county.
It can't be too difficult to find out who this guy is. I mean, I was talking with someone just the other day where they were saying, I can't remember where it was, but it had to do with the fact that all court documents, all of them, you had to use your full legal name when you signed. And so tickets have been kicked out, apparently, right? Where the police officer just used a first initial. And it's just not, no, the rule is you have to have the full name. He had to have filed this document, though, with his bar number. I mean, isn't that on there?
No. Nope.
Whoa.
I want to show it to you, but I got to show it.
Okay.
Also, he wants, listen, you're not going to believe this one. He goes, and also in this request, before any other court hearing, I need to see a complete background check. Everything that's happened to me since day one.
Now, are you able to tell us? Are you wanting to relate exactly what the charge is?
The only charge was I just didn't give him my ID, and that was it. And then the paperwork, the arrest warrants and all that didn't get released until about 8 weeks later. So I'm sorry, 6 weeks later.
So this is a failure to produce ID?
That is it.
Wow.
And a seatbelt. Remember, I was talking to you about this before.
Wow. For some reason, this guy is coming off more like an IRS agent than a prosecutor. Wow.
Yes. He
is wound a little bit too tight. Holy crap! I actually would like to get. That's supposed to be a violation of the rules. I can't cite it, so maybe I'm just speculating here. But I thought that attorneys had to put their bar number on every filing. Now that could just be a matter of custom. It may not be an actual rule, but wow! I'm okay. Would you have an objection with me trying to find out who this guy is and trying to line up a call with him?
No, not at all.
I want to know because look, no matter what happens here, okay, and if for some reason I can't get back with you, one of the things you need to know is what kind of psychological issue is it from the psychological handbook. I forget what the DMC, whatever it is. What particular psychological issue do you think you're witnessing with me? Do you think I'm delusional? What the hell's going on? Do you think that's the thing with Bao that never came out? What particular psychological issue were they investigating? Did he have Asperger's? I mean, what the hell was the problem here? Was he bipolar? Was he schizophrenic? I want just to have them be specific. What the hell, what kind of psychological problem, what recognized psychological problem do you think I have? And just to be...
Well,
Sorry?
Yeah, I just looked at the signature again. It's scribbled with a scribble line, and it says Assistant District Attorney. That's it.
See, at the top left-hand corner should be your name, and not signed, but it should be print, print out, like typed. It should have his name, his bar number, his address, his phone number. That's not in the top left-hand corner?
Nope.
Page 1, top of the caption?
Nothing.
You know what you need to do, and God help me, I know I need to get this template done. I am so sorry. I've been in California for so long now. I got in late last night at 3, and I got home Tuesday night, and just a couple days I'm out here again. I would start putting together, and you've got the evidence that this guy is unhinged, and I would file a claim as soon as I could with the county risk management that this guy is unhinged. There's something off with this guy, and he could severely damage me if he's got a judge who's complicit.
And another thing, too, he was extremely cocky, too. Like, he is the law, and that's it.
I don't understand how he could get away with doing this, and at no point was not going to give his name. How? I got to tell you, I think this is the first time someone who's being publicly prosecuted like this, especially just for traffic, where a prosecutor has refused to give his name. I mean, for goodness sakes, a lot of them out, at least what I've seen, a lot of prosecutors, they have a badge, and that's what gets them into court around the metal detector. You can just look at his badge. I guess maybe they don't have a metal detector. Okay. I guess. Okay. Well, resend that to me, and I'll address that, and I'll do what I can to track down who this guy is. Obviously, we'll be able to find out. I mean, what county is this?
Erie County.
Well, they're going to have a separate office for Evans, so it shouldn't be too hard to track it down. And so what is it, in the Evans Justice Court?
Yeah, it's a small little town, and I think there's several towns and villages in this county, probably about 20 miles south of Cheektowaga.
Okay, I will. Yeah, I'll. And the name of the court will obviously be on the pleading that you send me. So, I
already scanned everything to you and emailed it to your 2 email addresses on your website.
Okay, all right. I can't get it right now, but I'll get it right after the show. We only have 2 segments left for the big show today. Okay.
Thanks, Mark.
Yeah, not a problem. I appreciate the call, Shane in New York, and hopefully we've got
I never did file that motion for dismissal yet because I was so startled and so stunned I didn't know what to do.
But if you haven't filed the motion to dismiss and discovery request, then what the hell is he responding to?
I filed the motion for discovery and the motion to eliminate, but that's as far as I got.
Oh, see, the motion in limine is filed a few weeks after the discovery motion, the discovery request.
I did that. Yes, I did that.
Oh, okay. Well, it's okay. So you filed the discovery, you didn't get it, and then you filed the motion in limine, and then he responded by thinking that you're crazy.
Right.
Oh man. Oh, okay. Yeah. All right. I will. I'll check that out and do what I can to get in touch with this guy and maybe get some comments, maybe from him or his supervisor, to see what the hell, why he would think something like that. So, and all right, but I'll be in touch with you off air about it.
Thanks, Mark.
All right, appreciate the call. Holy crap! You know, I mentioned earlier on the broadcast that the Oh, we are back live here on the live stream. Welcome back, everybody. For those who we were just talking again with Shane in New York, and this is something for a traffic case, a failure to produce ID and a seatbelt charge. For a prosecutor to, he got the discovery request is asking for evidence to support the prosecutor's claims that just because he's physically in New York, the laws apply, and the name of the witness or person of first-hand knowledge he relies on. Pretty basic stuff. Unorthodox, yes, pretty basic though. And so the prosecutor is refusing to put his full name or even give his name. He's not putting his full name on the pleadings. So he filed a motion. He wants to have him basically committed. He wants a full psychological evaluation done. He wants a full background check. He's a prosecutor. You could just have the police do a background check. Why something like that is necessary in a minor traffic proceeding like this? This guy, holy crap. Yeah, so to say that this attorney was arrogant, yeah, no kidding. I guess his arrogance is short-circuiting his rational mind, if he indeed has a rational mind as a lawyer and a prosecutor. It's beyond the pale. I'm thinking not just a claim against the county's insurance as soon as possible because of this lunatic. If there's somebody who needs a psychological evaluation and doesn't play nice with others, it's this guy. And he's SS? Yeah. Maybe his last name is Stein. Well, no, I didn't mean that. I couldn't come up with another German name. I'm actually of the Steins of Hamburg. So no, he's not. He wouldn't be a Stein. Anyway, wow. I'm thinking that an Article 78 proceeding may be necessary. This guy, to stop this process, if the judge is going to give any legitimacy to this raving antisocial lawyer, so we'll have to see. Holy crap! I guess we could do turnabout here. Shane could file his own motion to requesting that the SS guy be given a psychological exam because he's obviously a bit unhinged and doesn't know how to respond to a motion like an adult. That is wow. Okay. Anyway, we're going to get back. He's been patient. We have Kerry from New Mexico. Welcome back, Kerry. What? Any good news this time, or are we still really in the thick of things?
Well, we're still in the thick of things, Mark. I had sent you an email also like this other man did, and you'd not responded, but I was wanting to get with you with a consultation. And you told the other guy to write you at markstevens.net. Now, I will do the same, but, and of course, I think I may have alluded to the fact that, obviously I'm another one of your people that have had their mental psych evaluations. It's a crazy world, the last time that I was in court, they told me, or that on my discovery, that the neighbor built a fence in the middle of the easement that it's a permanent structure, and of course, obviously, you can't do that in the easement. But somehow or another, he gave that to the prosecution, and somehow my question would be, is how can the prosecution charge me for his fence in the middle of a roadway?
Well, what are his grounds?
I don't know that, but obviously the state's acting as a third party intervener, and under equal protection underneath the law. Obviously, I don't see how they can move forward without giving me the same sort of protection and all these other things.
What grounds? What facts is he using to show that you're responsible to pay for this?
There's none. It's just in the court case. So my thing of it is I should be able to send some sort of documentation in. Just the last time we spoke, we certainly needed to refile a motion on the writ, but also too, I would like to file something asking for something, in fact, of how are they claiming that now their mailbox, which was that they had no damage, then all of a sudden now they were claiming $200 worth of damage. Now I'm having to pay for this fence that's over $2,000. So under those things, obviously we wanted to recuse the judge, but now I was thinking if it's over $2,000, wouldn't we be able to ask for a jury trial?
No, because this is a misdemeanor, right?
Well, not if the cost is over $2,000.
Well, it depends on the rules. I don't know if it's going to go to a felony. If it's it's probably $2,000 is probably not enough for a felony. But they're saying is that the fine or is that the restitution that they would order?
That's the receipts that he turned in for that they're demanding restitution for.
Yeah, well, restitution's not the same thing as a fine, so it's probably not going to have any bearing on.
But the thing of it is my whole issue is they're standing in my way of me suing this man because I can't sue him in their complaint, but yet they're taking up the responsibility of being like a third party intervener, because whatever issue this man has with me, he could certainly sue me. And why wouldn't the government bow out, or how could I get the government to bow out so that as two gentlemen we could square off? Well,
you could, if you wanted, file an action against him. It doesn't sound like they have so much control that the clerks would refuse a filing. But we've already discussed quite a bit on how to get the criminal charge thrown out if you can prevail on a lack of evidence proving jurisdiction in Brady violations. That's a pretty good start.
Well, it's obviously they keep moving forward because obviously the writ of prohibiting that was overruled on my last one, and that was my thing of that I needed to get with you to get that refiled, because the last time you and I had spoke, you had made mention that we needed to do something to refile on that. So we certainly need to move forward with that issue.
Okay. Well,
my thing of it is, could I ask this?
Sure.
If, in fact, that the prosecution is filing documents into the court, which this guy's claiming that I have to pay for a fence which wasn't up that he just installed, aren't they aiding and abetting some sort of criminal activity?
It could be. Have you sat down with the prosecutor in a pretrial conference so far and discussed this with him?
Well, I have multiple times, and the last time that we sat down, they were saying it was under $200. Then now I went to court this last time, and they handed me discovery, because that was my big thing when I went into court, is I hadn't had discovery. And then, of course, under this new discovery, we had all these bills that were over $2,000 worth of materials for this guy's fence. And, of course, he had to put the fence up because I guess maybe I'd ran over his mailbox.
Okay, well, hold on just a second. Hold on there. We're up against the break, so just hold tight. My name's Mark Stevens. You're getting into the last segment of the big broadcast today. I'm sorry about the audio quality on the YouTube stream. So we're not going to break any records today, but we'll be back and finish with our friend Kerry in New Mexico in just a few moments, so don't go away. Yes, welcome back to the No State Project. Last segment for the big show today. I am out of town, so I can't go over, but I'll do my best to get the audio up at markstevens.net, and I will be pulling this feed down as soon as I upload. I'll just put some graphics and put the good audio in, since the audio on this show was on the live stream was apparently so pretty bad. So that's why we're not Hitting some big numbers here today, but I'm glad for those who are tuned in, still tuned in. If you're having problems, again, just go to the LRN feed, and the audio is as good as it. Yeah, it's good. So welcome back. We're talking with Kerry. I think Kerry. Yeah, we'll have to discuss off air about doing the other action, because apparently, these guys just don't care. This guy's got a son that's in the sheriff's department, so that doesn't help matters much. That. Even if it was legitimate that you were to pay for the mailbox, to put a $2,000 bill on you for a fence, come on, talk about taking advantage. Have you asked the prosecutor if you could just pay for the mailbox? If they'd just throw it out?
Well, they did say that if I would just pay, but one of the things that I asked is, they came up with this number, $200, and basically they just uprighted a mailbox that was, he'd taken his mailbox out and he put it in the middle of the road where the easement, the edge of his property, but he has to maintain a 25-foot easement. He can't put permanent structures like fence in the middle of the easement. So I went over to the man that subdivided this land. Well, he's passed away, about a year ago, and he has a son that's maybe 55 years old, but his mother's still alive, which was the wife of the man that subdivided. And, she'd be in her 90s and frail, so I really didn't want to bother her. But I took all my plats and everything over there, and I was just trying to find out, because what had happened is the people that did the survey on several of these different plats, well, come to find out these guys are deceased, as well as the original one who drew it up. Because I was wanting, what I found out is that when these things were recorded, they may not, all the documents, all the I's weren't dotted, all the T's weren't crossed. But the plats certainly indicate that there's a 25-foot road easement. And with that knowledge, you can't sit there. This guy's got his own traffic signal. He's got his own stop sign. And this is in the middle of a county road. And for the simple fact that we're talking that his son's in the sheriff's department, we kind of put up with the old man for a lot of years, but up to the point where obviously he's blocking our access and egress.
Well, get a picture of that and send it to me. I want to see a picture of what this looks like. Give me some better context. So, and then
and the other, I don't know as to how good you are with Google Maps, but like my son and everything, we've taken all the photographs off of Google Maps for the last 10 years. And I as you well know, Mark, I've probably documented several hundred pages from my court case, but it's rather interesting because I really want to go in there and just maintain the part of jurisdiction, and keep asking the questions and then beating them over the head with it because, well, it makes me smile.
Well, and but you got to have this thing taken care of. So as we're doing this, I would still ask the prosecutor, look, this has been going on long enough. I think this is ridiculous, but you know what? What if I just give $200 for the mailbox, which is too much as it is, but hey, is that enough to make this go away?
And you honestly think that by paying them their bribe, that would be the fair reckoning? Because, that's what right before the break, that's what we alluded to, is I wanted some sort of reference in fact, some sort of thing that, well, if in fact that he incurred $200 a cost, then we would certainly do it. But, the guy was using the same mailbox the very next day, probably even the same day.
The thing is, Kerry, what we want to do, the main thing is we want you to be left the hell alone. You need to be relaxed and get out from under this. So you can always seek damages after, file a complaint against the county's insurance, and then maybe you'll get a better, you may fare better at getting the issues heard as opposed to now where you're not getting the issues heard, and you can even go into the higher court and you're not getting remedy. That's why I suggest that, just to make the criminal part go away.
Well, we finally made all of a sudden when this incident happened, we were is the background of this is all of a sudden I had two other cases on both of my properties, one on each one, for zoning violations and and we prevailed and all that. And they finally, it's not like I won anything. They just quit charging me with everything,
Well, that's
but ultimately they're making a significant case against themselves of basically we're under the theory that they should treat all people equally. But who knows? I really don't want to be one of their people. I just want to be left alone.
Well, and this may be a way to get there. It's worth investigating and see what what'll make it go away. You need to get this taken care of. You need to move on, and it's too much. I mean, so that's what I would do.
I think what I want to do is I will offer them $50 if they restitution in lieu of them proving some sort of evidence and fact of hardcore claims. Because I mean, obviously, a mailbox at Home Depot is only like $37.
Yeah, they want to stick it to you, and this has been going on for quite a long time. So it's about time to get this over. You probably have denial of a speedy trial at this point, as long as you haven't filed for a continuance. So that might be worth.
No, I hadn't. I bring up the 180-day issue or 182.5-day issue every time I'm in there too, but that doesn't. Obviously, when you're dealing with a vicious dog, he just barks, he just bites. There's no rhyme, there's no reason, there's no logic.
That's why it might be